On the night of the 7th of June, 2021, a lawyer in South Carolina told police where he had been that evening. He had been at the house, he said. He had taken a nap. He had driven over to see his mother. He had never gone down to the dog kennels. He repeated that account, in one form or another, for 20 months. To investigators. To his own family. Eventually, under oath, to a jury. What he did not know, on the night he first said it, was that his son had been filming at those kennels a few minutes before he died. A short video, 53 seconds long, taken on a phone, sent to a group of friends about a dog. Nobody looked at it properly for over a year. And on the audio of that video, plainly, unmistakably, there is a third voice in the background. It is his. This is a story about a family that ran the prosecutor's office in one American county for 86 years, and about what happened the one time the system had to be pointed at them. Hampton County sits in the lowcountry of South Carolina, inland from the coast, between Charleston and Savannah. It is flat, hot and thinly populated, pine plantations, soybean fields, blackwater creeks, small towns with one main street and a courthouse at the end of it. If you have never been to that part of the American South, the scale is hard to picture. Hampton is a town of about 2,500 people. Walterboro, the county seat next door, is 5,000. The distance between the family home, the law firm, the courthouse and the hunting property is about the distance across a single large city. About 18,000 people live in the whole county. Everybody knows the same names. And for most of the 20th century, one of those names ran the law. In 1920, a lawyer called Randolph Murdaugh was elected solicitor of the 14th Judicial Circuit, the elected prosecutor for 5 counties. His son took the office after him. Then his son. Then his son. For generations. 86 unbroken years, from 1920 to 2006. In that circuit, for the better part of a century, the person who decided whether you were charged with a crime was a murdaugh. It is hard to overstate what that arrangement does to a place. The solicitor decides what is charged and what is quietly dropped. If the same family also runs the biggest civil practice in the district, then the person who might prosecute you on Monday is the person suing your employer on Tuesday, and both of them are at the same barbecue on Saturday. None of that was secret. It was the ordinary arrangement of the 14th Circuit, and for most of a century almost nobody in it thought there was anything remarkable about it. Alongside the prosecutor's office they built a law firm in the town of Hampton, a personal injury practice, and a very successful one. If you were hurt on a road or at a plant in that part of South Carolina, you went to them. They knew the judges. They knew the juries. They were, in the most literal sense, the local law. There is a piece of local folklore about the family that turns out to be true. In 1940, Alex Murdaugh's grandfather was struck and killed by a train. The family firm sued the railway. The case against the railway was prosecuted in a courtroom in that same circuit, and the family recovered a substantial sum. The story is told there as a joke about how the Murdaughs never lose. It stopped being a joke in 2021. Richard Alexander Murdaugh, known as Alex, was born in 1968. He joined the family firm. He also took an unpaid appointment as a volunteer assistant solicitor, which came with a badge and a blue light for his car. He was, by every account from that county, hugely likable, loud, generous, first to the bar, first to help. He married Maggie Brandstetter in 1993. They had 2 sons, Buster and Paul. They had a house in Alameda, a beach place on Edisto, and a 1,700-acre hunting property near Island Ton called Moselle. Paul Murdaugh grew up inside that. He was a teenager with a family name that acted like a permit. There is a documented incident in which he bought alcohol underage using an identification card belonging to his dead grandfather, and the establishment served him, because of the surname on the card. Everybody in that county has a version of the same observation, that the boy was not unusually bad, and that nothing he did ever cost him anything, and that those two facts together are how you build somebody who eventually gets on a boat. The first crack in it opened in February of 2019, and it had nothing to do with the courtroom. Paul Murdaugh was 19. He and 5 friends took the family's boat out from a party. On the way back, at around 2 in the morning, the boat hit a bridge piling near Paris Island. 5 of them were hurt. One of them, a 19-year-old called Mallory Beach, went into the water and was not found for a week. The 5 survivors were taken to hospital. Mallory Beach was missing in the water. Search teams worked the creek for a week before she was found downstream. What happened in the hours afterwards is the part that mattered later. Witnesses described a confused scene at the hospital in which family members appeared before investigators did, and in which questions were asked about who had been driving. Paul was eventually charged with boating under the influence causing death. 2 years passed before Paul was even brought to trial, and he never was. The charges were pending on the 7th of June, 2021. In that time the family had, by several accounts, worked very hard to manage the case, who spoke to whom, what was said publicly, which lawyers were involved. The Beach family sued. And that lawsuit is the reason this story exists, because a civil suit means discovery, and discovery means somebody outside that county gets to look at the family's finances. It also meant that for 2 years, in a county where the name had always been an advantage, it became something else. People talked. The boat case was in the local papers every few weeks. Paul was recognized everywhere he went. The 7th of June, 2021, was a Monday. Alex, Maggie and Paul were at Moselle. At around 8:30 in the evening, Paul walked down to the dog kennels, several hundred yards from the main house, with his mother. At 8:44, Paul took out his phone and recorded 53 seconds of video, because one of the dogs had something in its mouth. He sent it to a group chat of friends. In the audio, 3 people are speaking, Paul, his mother, and a man. Within about 4 minutes of that recording ending, both Paul and Maggie Murdaugh were dead. Paul was shot twice with a shotgun. Maggie was shot with a rifle. Neither weapon was ever recovered. It is worth being exact about the geography, because the trial turned on it. The Kennels were about 400 yards from the house, out of sight of it, down a lane. A person at the house could not see the Kennels. A person at the Kennels could not be seen from the house. And a vehicle moving between the two took under a minute. At 10:10 that night, Alex Murdaugh telephoned emergency services and said he had come home and found them. There is a detail from the first interview that became important. He was asked, that night, whether he had any idea who might have done it. He raised the boat case immediately, that people were angry about Mallory Beach, that somebody might have come for Paul. He offered a motive before anyone asked him for one. His account was this: he had been asleep at the house, had woken, had driven to see his mother in Alameda, she had dementia, and his father was in hospital and dying, had stayed a short while, and had come back to find them by the Kennels. He said he had not been down there at all that evening. The recording of that call was played at trial. On it he is breathing hard and describing what he can see. He tells the operator he has checked them, which investigators later argued was inconsistent with the physical evidence about where he had and had not been. In the days that followed, the state police issued a public statement that there was no danger to the community. In a county that had spent 72 hours believing a killer was loose, that sentence was noticed, and people worked out what it implied. 3 days later his father died. The funerals ran together. The county closed around the family the way small places do, and the working assumption, publicly and privately, was that somebody had come for the Murdaughs because of the boat case. For 3 months the investigation went nowhere in public. Then, at the start of September, the whole thing came apart in the space of about 72 hours, and none of it was about the murders. It is worth pausing on who found it. Not an auditor, not the Bar Association, not a regulator, and not a court. A colleague at his own firm noticed that a fee had not landed where it should have, and asked one question, and did not accept the first answer. On the 2nd of September, the partners at his own law firm confronted him. They had found missing money, fees that should have gone into client accounts and had gone somewhere else. He admitted taking it. He resigned that day. On the 4th of September, 2 days later, Alex Murdaugh was found on the side of a road in Hampton County with a gunshot wound to the head. He told police a stranger in a truck had shot him. Within a fortnight that account had collapsed too. He later admitted, arranged for a man he knew to shoot him, so that his surviving son could claim $10 million in life insurance. The shot grazed his skull. He survived it. The man who fired the shot was Curtis Edward Smith, a distant cousin by marriage who had been cashing checks from Alex Murdaugh for years. The arrangement, as charged, was that Smith would kill him on a roadside so that the death would look like the murder of a grieving father and the $10 million policy would pay out to Buster. Think about the arithmetic of that. 3 months after his wife and younger son were shot, he judged that the most useful thing left to him was his own death, priced at $10 million, arranged by telephone. And once the state started pulling on the financial thread, the size of it became clear. Over roughly a decade he had taken client settlement money, millions of dollars, from people who had come to that firm because they had been badly hurt and did not know where else to go. It is worth naming what that means, because the phrase financial crimes does a lot of hiding. In 2018, the family's housekeeper of some 20 years, Gloria Satterfield, fell at the Moselle house and died a few weeks later. Alex Murdaugh told her 2 sons that they should bring a claim against him personally, and recommended a lawyer, a close friend of his, to run it. The claim settled for over $4 million. Her sons received none of it. They did not know it had settled. They found out years later, from a newspaper. The mechanism was simple and it worked for a decade. When a case settled, the money was supposed to go into a client trust account at the firm. Instead he had checks made out to an account he controlled, opened in a name that looked almost exactly like a well-known financial services company. To anybody glancing at a check stub, it read as a legitimate structured settlement provider. There was a young man who had been left a quadriplegic in a road accident, and who was deaf. There was a state trooper. There was a family whose settlement money was supposed to pay for the rest of a life of care. In case after case, the money was routed through an account he controlled with a name designed to look like a legitimate financial firm. The total eventually pleaded to was around $8.5 million, across dozens of clients, over about 10 years. He had been stealing from injured people in the same courthouse district where his family had decided, for 86 years, who got prosecuted. That is the context that matters for what the prosecution later argued about the murders, not greed as a motive in itself, but exposure. On the 7th of June, 2021, a hearing in the boat case was days away, and a judge had ordered him to produce his financial records. There is one more thing about the money that explains the timing. He was not stealing to get rich, by any normal measure he already was. He was, on the evidence, moving money constantly to cover holes left by earlier movements, and by 2021 the holes had stopped being coverable. On the 10th of June, 3 days after the murders, a hearing in the boat case had been scheduled at which he would have had to hand over his financial records. That hearing did not happen, because the family was burying 2 people. The murder investigation, meanwhile, had been quietly doing what murder investigations do, which is to build a timeline out of machines. Every phone in that house was producing a record, steps counted, screens locked and unlocked, signals to towers. Maggie's phone stopped recording motion at 8:49 in the evening. Paul's stopped at 8:49. Alex's phone, which had recorded almost no steps all evening, recorded a burst of nearly 300 steps between 9 and 9:02. His vehicle told its own story. The onboard system logged the moment the engine started and the speeds he drove to his mother's house, including a stretch at over 70 miles an hour on a road where that is not a normal speed for a man who has just had a nap. But none of that would have been enough on its own, because all of it was consistent with a man who was in the house and then drove to his mother's. What it needed was one fixed point that put him at the Kennels. The video was on Paul's phone the whole time. It had been sent to friends. Investigators had the handset. What they did not have, for months, was the passcode, and then, once they had it, somebody had to sit and listen to 53 seconds of a young man talking about a dog, and recognize a voice in the background. When they played it to people who had known Alex Murdaugh for decades, his surviving son, family friends, colleagues, every one of them said the same thing. That is Alex. The trial opened on the 25th of January, 2023, in the Hampton County Courthouse in Walterboro, a white columned building on a small square, 190 years old, with a courtroom that seats a couple of hundred people at most. The judge, Clifton Newman, had been a circuit judge in South Carolina for over 2 decades. He had known the defendant professionally for years, as almost everyone in that building had, and he ran the trial in a way that got remarked on nationally, slowly, formally, and without letting the size of the audience change anything about how the room worked. It ran for 6 weeks. It was carried live. For a stretch of that winter it was the most watched courtroom in the world, which is a strange thing to happen to a town of 5,000 people. One evidentiary fight decided a great deal of it. The judge allowed the jury to hear about the financial crimes, the thefts from clients, on the argument that they went to motive. The defense fought that hard, because a jury that hears about a decade of stealing from injured people is a jury that has already decided what kind of man it is looking at. The prosecution's case had 2 halves. The first was the timeline, phones, vehicle data, weather, the exact minute of a dog barking. The second was much simpler, that he had lied about where he was, to everyone, immediately, and had kept lying for 20 months. The defense argued that the financial crimes proved nothing about murder, that no weapon was ever found, that there was no blood on him, and that a man who had just killed his wife and son would not then telephone the police and stay on the line. Then, against the advice that almost every defense lawyer in the country would have given, Alex Murdaugh took the stand himself. He admitted, on the stand, that he had lied about the Kennels. He said he had lied because of paranoia brought on by opioid addiction, and because he did not trust the police in his own circuit. He was on the stand for the better part of 2 days, and he cried, and he was, by most accounts in the room, extremely good at it. The prosecutor's cross-examination did not try to catch him out on the murders. It walked him, slowly, through a decade of thefts from named clients, and asked him each time whether he had lied to that person too. He said yes. He said yes about 50 times. There was a moment in that cross-examination that people who watched the trial still talk about. He was asked, in effect, whether he was a habitual liar. He agreed that he was. The prosecutor then asked why the jury should believe the account he had given them that morning, and there was no useful answer available, and everybody in the room knew it. On the 1st of March the jury was taken out to Moselle to walk the ground between the house and the Kennels. On the 2nd of March they retired to consider. They came back in under 3 hours. Guilty on all counts. The following morning the judge sentenced him to 2 consecutive terms of life imprisonment, and said from the bench that he had seen a lot of defendants in that courtroom over the years, and that this one had been, for a long time, on the other side of it. Buster Murdaugh, the surviving son, sat in that courtroom for 6 weeks. He had lost his mother and his brother, and he was watching his father be convicted of killing them, in a building his family had effectively run for a century. Whatever one thinks of the verdict, that is an almost unbearable position to be in, and he has said very little publicly since. The financial cases were dealt with separately and quickly, because there was nothing left to contest. He pleaded guilty in federal court to 22 counts, and in state court to 22 more, and received sentences of 40 years and 27 years to run alongside the life terms. Then, in September of 2023, his lawyers filed a motion for a new trial. Their claim was not about the evidence. It was that the clerk of court for Hampton County had spoken to jurors during the trial, had pressed them towards a verdict, and had done so while working on a book about the case. The claim was specific, that during the trial the clerk of court had told jurors not to be misled by the defense, had asked them about their leanings, and had removed one juror on grounds the defense said were pretextual. The clerk had a book about the trial in progress, published within months of the verdict. A retired Chief Justice was brought in to hear it. She interviewed the jurors one by one. In January 2024 she refused the new trial, finding that whatever had been said, it had not changed the verdict. The clerk of court resigned that year during an ethics investigation. The appeal has continued through the higher courts since. There is a separate thread that has to be handled carefully, because it is the part of this case where speculation runs hardest. In 2015, a 19-year-old called Stephen Smith was found dead on a road in Hampton County. It was recorded at the time as a hit and run, a finding his mother has never accepted. In 2021, while working the Murdaugh murders, state agents said they had opened an investigation into his death based on information gathered during that inquiry. His body was exhumed in 2023. It is now treated as a homicide. Nobody has been charged. Investigators have said publicly that they have found no evidence linking any member of the Murdaugh family to that death. It sits where it sits, an open case, a family who want an answer, and a great deal of internet certainty that is not supported by anything on a file. So the position, as it stands, is this: he is convicted, he is serving 2 life sentences, and there is a live legal argument about the conduct of the court around him, which is, if you think about it, an extremely on-brand ending for this particular case. A word about what this case became, because that is part of the story now. The trial was streamed gavel to gavel. Podcasts covered it daily. Documentary crews were in Walterboro before the verdict. A town of 5,000 people had its square filled with satellite trucks for 6 weeks. Some of that coverage was careful. A great deal of it was not, and it fed a second industry of speculation about every death within 30 miles of that family over 20 years, most of it built on nothing, some of it aimed at people who had lost somebody and did not consent to being content. Maggie Murdaugh was 52. Paul Murdaugh was 22. Mallory Beach was 19. Gloria Satterfield was 57. Those 4 names are the reason any of this is worth telling, and they are the 4 that get least of the attention. Moselle was sold. The house where it happened stood empty for a while and was bought by a family from out of state. The property has since been broken up. People still drive out there, which the neighbors are not enthusiastic about. The Beach family's civil case was eventually settled. Gloria Satterfield's sons received the money that had been taken from them, years late. A number of the other clients have been repaid out of what could be recovered. Gloria Satterfield's sons, Tony and Brian, eventually received the settlement that had been taken from them, together with money recovered from others who had handled it. It took a public scandal, a criminal investigation and several years of litigation to deliver an outcome that a functioning client trust account would have produced automatically in 2019. The law firm his family had built for 100 years changed its name and continues. The county has had its name in every newspaper in the English-speaking world, which is not what a place of 18,000 people wants. There is one more group worth mentioning, and they are not in most tellings of this. The other lawyers at that firm, the ones who did not steal anything, lost the practice their careers were built in. The staff lost their jobs. The clients whose cases were legitimate had them handed to strangers. That is the ordinary wreckage around a case like this, and it never makes a documentary title. There is a temptation, with a story like this, to make it about one unusually convincing man. It is not really. The financial thefts ran for about 10 years, through a firm, in a district, in front of people who had every professional reason to notice. It is also worth noticing which institution did work. Not the bar. Not the local courts. The thing that broke it open was a colleague asking a question, and then, much later, a state agency from outside the circuit taking the case rather than leaving it with people who had known the family for 30 years. South Carolina has since changed how attorney trust accounts are monitored, and how conflicts are handled when a case touches a sitting or former solicitor. Those are dull reforms. Dull reforms are usually the only real output of a case like this. They were not stopped by an auditor or a regulator or a court. They were stopped because a 19-year-old girl died in a boat crash, and her family had the nerve to sue a name that nobody in that county sued, and a judge made him open his books. And the murders were not solved by the badge he carried or the circuit his family had run. They were solved by 53 seconds of video that a 22-year-old took of a dog, for minutes before he died, and sent to his friends. You can see the shape of it clearly now, which is the advantage of hindsight and the reason hindsight is not worth much. A boat crash in 2019 produced a lawsuit. The lawsuit produced a demand for financial records. The demand for records produced a deadline. And 4 days before that deadline, 2 people were shot at a set of dog kennels. The prosecution never had to prove that chain, because a jury only has to be sure of the killing. But it is the chain the state put in front of them, and it took them under 3 hours. If there is a lesson underneath all of it, it is not that powerful families are dangerous. It is that the ordinary checks, an audit, a client statement, a question at the front desk, only work on people the system is willing to point at. Thank you for watching Picket Fence Crimes.